SJC-12568, Commonwealth v. Abdullah Yasin.
Mr. Armstrong, good morning.
Good morning, Your Honors. May it please the Court, Yasin Armstrong on behalf of the Commonwealth. With me this morning is Assistant District Attorney Tara Birdman, the trial prosecutor below. This court should vacate the trial judge's post-verdict Rule 25A ruling that the defendant was entitled to a not guilty at the close of the Commonwealth's case and allow the Commonwealth the opportunity to challenge the remainder of the judge's decision.
Let me ask you a question at this point. My understanding of what's in the record is that it does not contain the entire transcript. Is that right?
That's correct, Your
All right.
Honor.
So when we analyze this, we are unable to look behind the veil, so to speak, and see whether, in fact, the evidence was sufficient or whether, in fact, the evidence was insufficient.
Correct, Your Honor.
So we have to decide this case totally on the law. Is that what you're saying?
Yes, exactly. We're looking specifically at Rule 25.
And my understanding of Rule 25 is that Rule 25A has to be done and cannot be reserved.
Yes, the rule allows, gives two options. The court can allow or deny the option.
But it cannot be postponed, and so, and a Rule 25B, however, you can appeal from that, but you can't appeal from the 25A.
Correct, a Rule 25B post-verdict.
So what we're dealing with essentially is your right to appeal this in one way, and then the other thing is that the defendant, tell me if I'm right about this, had an advantage to some extent if the judge in fact believed the verdict was, that the evidence was insufficient, but delayed ruling. By not letting the by doing that, she enabled you to have a right of appeal that you would not have had.
Correct, had she ruled on the 25A at that time.
Right. And so had she ruled at the 25A, the defendant would be facing a situation of
An unreviewable acquittal.
Right, an unreviewable acquittal.
Yes.
So the stakes are high for
Correct.
both sides here.
So
Yes.
isn't the bottom line who bears the burden of the screw-up by the judge?
No, Your Honor, because what the judge had no power.
The judge screwed up, where everyone agrees with that, right?
Correct.
So that everyone agrees with the fact that the judge screwed up. The question is who's going to bear the burden of that? Is it going to be a Rule 25A fix, or is it going to be a Rule 25B by definition?
So Rule 25 is written so that if the judge does err, you have multiple opportunities to correct that. You have the 25B motion at the close of all evidence, as well as the 25B2 motion
But if
post-verdict.
she was going to make the Rule 25A ruling that she made, you wouldn't have been able to appeal it at all.
That's correct, but
So
she
the question is
didn't.
who's going to bear the burden of the judge's mistake?
I don't believe anyone is bearing the burden, Your Honor, because the defendant had the opportunity at the close of all evidence and
But he would have been appealable, that would have been appealable, would it not?
it would have not been appealable had she ruled on the 25A or the 25B1 motion.
Okay.
But the prosecutor never stood up and said, Your Honor, you can't reserve under 25A, then make the argument why the evidence is sufficient. There was no
Well-
211.3, and now the judge is, at the end of the trial, is saying, oh, my goodness, I couldn't do that, but it should have been the equivalent of a not guilty, so I made a mistake, and I want to change it.
Which is exactly what Rule 25B2 is for. So the Commonwealth respectfully did stand up at the close of their evidence and argue that the evidence was sufficient. We had a very extensive hearing. This was an incredibly complex case where the prosecutor stood.
But we don't know any of that. right? It's not in the record in front of us.
It is attached to my brother's appendix. You have an excerpt of the 25A argument.
Okay, so we have the argument, but we can't go
Just our-
back and say, gee,
No, but my
how hard
point-
was it?
But my point is not that. My point is that I understand the prosecutor said why the required findings should be denied, but the assistant district attorney never said you can't take that under advisement.
No, but nobody said that, Your Honor. And respectfully, the judge has no
I
power.
thought that the defense attorney did.
I mean, I've read it.
Yeah.
Mr. Defense Counsel did.
He asked that his defendant was entitled to the ruling at that time, not
Right,
specific.
wasn't he? I mean, that's really, how else do you say it?
Sure, but the Commonwealth had just stood up and argued that the Commonwealth was entitled for the motion to be denied and the case to continue.
So what?
So that's the equivalent of,
Didn't the prosecutor have the burden of telling the judge you can't do this? You can't do this because you'll be in violation of Rule 25A, which requires you to do this?
yes, best practice would have been for the
Best practice.
Best practice would have been for the Commonwealth to stand up and do that, but the judge made abundantly clear that her practice in the 23 years she was a trial judge was to reserve on this motion and allow the case to
But
continue
there's
and
no
give it to
objection
the...
by you, or I'm sorry, by trial counsel for the prosecutor.
No, you're correct, Your Honor. There was no objection, but
But the defendant was consistently saying that he was entitled to it then, right then.
yes.
But you don't know how the judge is going to decide at that point, do you? I mean, she's giving signals, but, I mean, to blame you guys, I mean, the judge, defense counsel wants her to rule, but no one knows exactly how the judge is going to rule. The judge doesn't say, I'm granting it at this point, but I'm going to wait for the jury. The judge is kind of indecisive, right?
Right,
She doesn't
when-
know, she wants to basically have this taken away from her.
Yes, she wants the jury to make the decision, which, as I point out in our brief and as I submitted the 16L letter, by not ruling on this motion, it's the equivalent of a denial. The judge cannot look at a 25A motion and say, I'm going to reserve on it when the rule explicitly says you have to allow or deny it, then allow the case to go to a jury and the jury return a verdict. The most important piece of our criminal justice system is that jury verdict. And then the judge say, oh, I made a mistake under 25A. Now I'm going to go back in time as if I actually had ruled on it and rule on that motion.
But just assume, I mean, Justice Link made this point already. Just assume it was completely the wrong procedure, which it was.
Sure.
Isn't the judge, when the jury comes back guilty, the judge could have done 25B and allowed the review. But the judge is saying, oh, I made a mistake here. By saying I'm doing under 25A as well, the judge is saying, I would have allowed the required finding. Isn't she saying that?
She might be saying that, Your Honor, but that isn't what she did. That isn't what happened. We had the jury verdict in place, and she also ruled in the alternative under 25B2 so that the Commonwealth would have that right of appeal.
Isn't
there's
there
a-
something dangerous about allowing judges to do this? Because
Yes.
essentially, if we've got some rogue judge, we're basically left with impeachment if judges do this kind of
It
thing.
it
right?
eliminates the need for a jury trial if a judge is allowed to do this,
A
because then
judge can
every
do this, right? A judge can basically say, okay, I'm going to send it to the jury, and then I'm going to have a 25A nunc-pro-tunc that's unreviewable. So no matter how silly my decision is, it's unreviewable. There's something, I mean, I understand the judge goofed up here, but there's something even more problematic about creating a nunc-pro-tunc procedure, isn't there?
Correct, because you would then be trying the case before the judge instead of the jury. The jury verdict would be completely irrelevant.
The judges
Well,
would
isn't this
basically.
sort of just a remnant left over from the de novo system and when they could go to the bench trial and then the jury trial, and this has been going on for a long time, which is why it's in the rule now that you can't do it.
Why the judge cannot reserve on the
Not-
25A?
They cannot reserve under 25A.
Correct, which is such an important part in the trial that
Right.
the judge has to rule on it at that time, which I believe, as Your Honor points out, is why the rule is written that way. It doesn't give the judge the discretion to reserve on it or to contemplate it, because at the moment the judge says, And in this case, the judge said, I'm reserving, and the defendant entered his first piece of evidence. We are out of the realm of 25A. You can no longer act under that 25A motion, and we're only in the realm of 25B.
So are you arguing now that this is in effect a constructive 25B? That the 25A became a 25B?
Yes, and in our brief, I point out that it's an implicit denial by reserving, and that implicit denial puts us specifically in the realm of 25B.
Although that's a little strong, isn't it? Because, I mean, the judge is clearly leaning the other way, so.
I don't believe it's strong, Your Honor, but explicitly the way the rule is written. The rule says you can allow or deny. So if any judge says, you know, I'm going to think about this, I'm going to reserve, we're going to let the case proceed, you haven't allowed the motion, you have implicitly denied it.
Well, a judge can't hedge his or her bets by what the jury's going to do.
Correct.
So the point of 25A is the evidence on its face after the government's presentation of the evidence is insufficient, case ends.
Insufficient as a matter of law.
As a matter of law.
And we're not looking at the weight.
I'm not going to have the jury save me with a not guilty. That's where 25B, 1 and 2 come in.
Correct, yes. 25B gives you that option at the close of all evidence to reserve.
So what do we do with Brangan 1? There, the judge, after closing argument, Your Honor, I asked for a mistrial based on the closing argument of counsel. Judge said, I'm going to reserve that decision. After the jury's verdict, he says, I should have ordered a mistrial. I order a mistrial, and we struck the notice of appeal.
Sure, so I don't believe you have to do anything to that case, Your Honor. I believe this case is distinguishable for 2 reasons. First being that a mistrial does not dispose of a case with finality. The mistrial, instead of disposing of the case completely, simply reverts the Commonwealth back to retrying the case.
The difference is that if you had an appeal, you could have argued that the appellate court could have said, if he had done it after the case and had not nunc-pro-tunced it, we could have said that's an error and that we affirm the conviction.
Correct, because you would be looking at the entirety of the
Right,
record.
but the result was whether or not, the issue was whether or not the appeal could go forward on the Commonwealth side, and we said it could not.
Correct, but that goes back to it being a mistrial and for the fact there, Your Honor, that the defendant objected to the mistrial before, I believe after closing arguments, before it went to the jury. So I believe what this court was saying was that that error was so extreme that that jury verdict could not have been a true verdict and a just verdict. So the only remedy would be...
No, we didn't. We struck the appeal. We didn't reach that issue.
But you allowed the case to go back to be retried.
But yeah, we did.
So that's the difference here. If this case is allowed to stand, there is no retrial. The judge's 25A nunc-pro-tunc ruling is a final ruling.
But the defendant would say it's just the opposite. If it can be retried, he was found not guilty, really, by the judge. That was her intention, obviously, or she wouldn't have done the 25A after trial. And then yet, even though the judge says the evidence was insufficient at the close of the Commonwealth's case, there still can be a determination that there was sufficient evidence. And that doesn't seem right. It goes back, I guess, to where Justice Link started here. It's a matter of justice here. Who bears the burden of the mistake? I think that's the question, the one Justice Link asked.
Well, respectfully, we're not looking to retry the defendant. We're looking to reinstate the jury verdict.
I understand.
Which is, at this point, we have to assume that it was a just verdict and the jury...
But we can't assume that. We don't have the record. And, I mean, we can't assume that, especially if we have a judge saying at the close of your case, there may not have been sufficient evidence. In fact, now that I think about it, there wasn't. And she goes and puts in the 25, the directed verdict. So I don't see how we do assume that.
Because we're looking specifically at the law here, whether or not the judge has the power to do this and what she did.
Well, she doesn't.
Exactly.
Isn't that for another day? That's why she reserved, that's why she, in the alternative, found under 25B2.
Yes.
So the sufficiency can be litigated somewhere else.
Well, and that is the Commonwealth's intention pending this appeal is to appeal that to the appropriate court. And that's all we're seeking here is to have that decision reviewed by a higher court. By allowing the court to insulate her decision from review, as Justice Kafka pointed out, creates a much bigger problem of eliminating the need of a jury verdict and trying the case specifically for the judge.
I guess I don't see this situation replicating itself, though, because
Hopefully not.
if the judge thinks that the evidence is insufficient, there's no review, but the judge has an obligation under the law to allow the required finding.
Correct. In the clearest of cases, that's what the judge is supposed to do. But the default, I would argue, is to give the case to the jury and allow the jury to decide.
No, that can't be the default, because first of all, the rule says you can't do that. And secondly, part of the reason for the rule is it's fundamentally unfair to the defendant, who now has to decide whether to take the stand and arguably strengthen the case against him. Now, yes, I understand that we would be evaluating it based on the evidence at the close of the Commonwealth's case, but it's a little bit harder for a defendant to prevail on an insufficiency matter where the defendant then chooses to testify because the judge doesn't make a decision and then suddenly is making admissions that indicates that the evidence, at least in its totality, would certainly be sufficient.
But that's why the rule is created the way that it is it gives the defendant those multiple checkpoints, the checkpoint at the close of the government's case, at the close of all evidence, and again after the verdict. And then if the judge says that each of those times there is sufficient evidence, the defendant has his right to appellate review, where a higher court will look at that point in time before he puts on his evidence as to whether or not the evidence was
What
insufficient.
more should the defendant have done here to get 25A?
I'm sorry?
What more should the defendant have done here to get the 25A ruling at the time it was supposed to be given? If the judge won't do it, the judge won't do it. What is the lawyer supposed to do? Was there something else that you think the defendant should have done?
No, I think if it was the strong enough case, you could request to stay in a 211-3 to the single justice, but the case is going to go on. If the judge isn't going to rule at that time,
Wasn't, and she wasn't. She made it clear she wasn't.
correct. And if she's not going to do that and she doesn't think that there is insufficient evidence and lets the case continue,
So you're saying that in the future, if this is to happen, that you think that the defendant should take an appeal to us, to the single justice?
if the judge refuses to rule on the sufficiency,
Yes. So
if
you're
the
saying-
judge says, I'm refusing to rule on the sufficiency or I'm reserving, and the defendant and or the Commonwealth could take that exact same 211-3 and order the judge, or request the single justice to order the judge to rule on that 25A.
So you think that should be the remedy? For us
No.
to say going forward?
No, I believe the remedy is built into Rule 25, that if the judge doesn't rule,
But don't you agree with Justice Link? I mean, that the remedy is, I mean, you guys, this was brought as a single justice matter after the error is incurable.
correct.
If
Well,
the
post-verdict,
error,
yes.
if the single justice matter had been brought before the verdict, then the defense counsel could have gotten a decision on the Rule 25A, and we wouldn't be here. So isn't Justice Link right? Isn't that the remedy here? Because these default rules don't really make sense.
Just agree. As,
No, he's allowed to make up his own mind.
no, that's fair, that's fair. But doesn't it come back to if the trial counsel didn't file a 211-3, that's sort of on the Commonwealth, right? Because there's no question that there was a mistake made by the judge. And I think it comes back to what Justice Link was saying. Why is it that if there's a mistake made by the trial judge, that the defendant bears the brunt of that? And I don't know if that question's been answered. It doesn't make sense for the defendant who specifically asked for
Sure. So I believe it's fair in that the defendant's constitutional right is to not be convicted on insufficient evidence. And that right is protected under Rule 25. Rule 25 creates two additional benefits to that. that can come earlier in time than the jury verdict, but the defendant's constitutional right, in this case and in all cases, is protected based on that jury verdict.
But not if we don't accept that that was a 25A and say the evidence is insufficient and you can't
Correct.
review it. Then you lose your right of appeal.
Yes,
And that's the only way that the defendant's constitutional protections really blossom. Don't they?
I would disagree.
In this case.
I would disagree with that characterization because the defendant still has the opportunity to not be convicted on insufficient evidence. And in fact, that's what the trial judge did, setting aside the 25A ruling. She ruled under 25B2, the defendant is entitled to a not guilty. So she used that final checkpoint to say, I find there's insufficient evidence, the defendant should be found not guilty.
But isn't Justice Budd's question, you're the winner when you do nothing. So isn't it Mr. Sultan's client who has to bring this up, not you? You can sit there, you won.
At 25A?
No, I mean, the single justice point, I don't know why you're not jumping on this, but Justice Budd goes, you should have appealed this. No, you won. He should have jumped in, right? Because you're the
Correct.
winner.
Correct. At that point in time, that's correct.
But isn't there an obligation, the prosecutor, to say, Judge, that's just wrong?
That's wrong.
Mr. Sultan is correct, he is entitled to it?
It's Berger versus the United States. The government always wins its case when justice is done. So the prosecutor has to stand up and say, Your Honor, you have to make a ruling.
Have to make a rule, yes, and the Commonwealth should have done that.
Okay, so what's the consequence for the Commonwealth's failure to do what it should have done?
I guess the Commonwealth has an obligation to tell the judge what the law is?
No, Your Honor.
Assume
No,
the judge knows the law?
the judge is supposed to follow the law, and
Got a pretty experienced Superior Court judge here on a pretty complicated question of law that, to be honest, it's not intuitive that you don't get an appeal when a judge cuts that thing off.
no, it isn't. But at the same time, the judge should be able to apply the clear and unequivocal language of Rule 25A at that time.
So are you saying that if 25B2 is allowed, it automatically assumes a 25A?
In the sufficiency of the evidence, depends on the judge's finding. The judge has to make those findings at that time, whether the evidence was insufficient which would actually be under a reserved 25B1. If it's under 25B2, the judge has to say whether or not the conviction was consonant with justice or against the weight of the evidence. So that depends specifically on the judge's findings at that time. If there's no further questions, thank you.
Mr. Sultan?
Mr. Chief Justice and members of the court, before I present my argument, I have to make a correction. On page 40 of our brief, we address a case, Balch versus Shaw, an 1851 case in this court. We note in passing that that was not a nunc-pro-tunc case. In fact, it was a nunc-pro-tunc case. It doesn't affect any other part of my argument, but it was a mistake. So I need to correct it, and I apologize to the court for that error.
Sultan, suppose we agree with you, and you appropriately said, you can't do this, you can't reserve, and the judge said, for whatever reason, ignored you.
She gave the reasons why she ignored me, Ron. She gave them she very clearly stated, both at the time and subsequently, the two reasons why she deferred over my objection.
It's her practice, and she wants to see what the jury's going to do.
No, those are not the two reasons. The first reason was because she believed erroneously that if she allowed the motion at that time, that the Commonwealth would have a right to appeal that ruling, that allowance of the motion for required finding, and that if she were reversed on appeal, the whole case would have to be retried. That was reason number one, based on her erroneous belief about that. Reason number two was that she believed, based on her experience, that given the fact that the only lawful verdict in this case was, on the murder indictment, was not guilty due to the lack of evidence presented by the Commonwealth, she believed that the jury was going to find the defendant not guilty. Well, she was wrong about that, too. Those were the two reasons she deferred.
So then it goes to the jury. Now you're in 25B 1 and 2 world, right?
Well, no, I'm not, Your Honor, because
If you wait for me to ask the question
Yes,
before you
sure.
answer
Sorry.
it, all right? And then you convince her to do this non-pro-tunc. The question I'm going to ask you, Mr. Sultan, is what if we agree with you, does it eviscerate 25A and the provision of 25A where it says it has to be done at the time? Because now we're saying to judges, you can reserve and you can revisit it non-pro-tunc. What about the next case?
Your Honor, let me respond as follows. Number one, it is clear, everybody agrees, the parties agree, it's indisputable based on the plain language of Rule 25A that, as Justice Link put it, the trial judge screwed up. That happened. Okay. This case, frankly, what happened after that exemplifies exactly how our criminal justice system should work when a serious procedural error occurs at trial. She made a mistake, she deferred it erroneously, then the jury comes back with a second-degree murder verdict, and then she does two things. She rectifies that unlawful verdict, and she rectifies the timing error that she made. She does both of those things by granting the motion non-pro-tunc, thus restoring the parties to exactly where they would have been had she made that ruling when she was supposed to make that ruling.
Not really, because
That's the system working.
actually, I mean, and to your credit, you understood this and she didn't. But you also could have taken a single justice appeal, and then we wouldn't, and that would have kept us in the status quo, because once we have a jury verdict, we're not in the status quo. And the judge isn't as definitive as you think she is. The judge is waffling. She wants to see what the jury does, to confirm her sort of instinct here. But she hasn't made up her mind, or she would have decided it, didn't she?
I don't agree, Your Honor. I think she had made up her mind because she made it clear.
Forget about that point for a second. Isn't the solution to this, because this is a mess, isn't the solution to this a single justice appeal once she doesn't rule on 25A? Justice Lank's earlier point.
I understand the point Your Honor's making. And of course.
I'm not second guessing the way you did this, but because this, until Justice Link said it, I'm not sure we thought of it either. But
Well, I think it's
but
I'm here to
isn't
be
that the
second-guessed.
solution to this case?
Well, no. And of course, yeah, I could have, at that moment in the trial, I could have said, Judge, I'm taking a 211-3. I have to make a tactical decision as a trial lawyer, that situation, having listened to what the judge said very carefully, both on March 15th, when she first said she was going to reserve, and on the morning of March 16th, when she said not only that she was going to reserve, but that in order to convict the defendant, the jury had to find beyond a reasonable doubt that the identified shooter was not acting in self-defense when there had been no evidence at all on that point put in by the Commonwealth. I had to make a tactical decision. Do I really want to, and I'll use a vernacular term, piss this judge off by stopping this jury trial on a Friday and going and filing a 211-3, or do I want to figure out some other way to make this work? And I made a decision which I believe was in my client's interest, and I don't think it's fair for this court to say to a defense counsel in that situation, thou shalt file a 211-3. I just don't think that's fair. And to answer Justice Graziano's question, I don't think there is a next case, because I think this court can say in no uncertain terms, as it said over and over again, trial judges, you may not defer this decision. You have to rule. You have to rule at the time that the motion is made, at the end of the Commonwealth's case. You have to follow the rule. It doesn't give carte blanche to judges to ignore the rule. No judge is permitted to ignore the rules.
So if you were writing the decision, you would say, we're going to give you non-pro-tunc in this case because there was an error, you rectified the error, but don't do it again.
Well, that's one of the grounds for relief, but I think that Chief Justice Gantz was totally correct in raising the Brangen decision, because in the Brangen decision, what this court said is they treated a post-verdict granting of a mistrial motion. This court said, we're going to basically not let the Commonwealth appeal. We're going to treat it as though it were granted before the verdict because, this court said, defense counsel filed the motion at the earliest possible time. That's what happened in this case. This court said the timing of the decision doesn't change the character of the motion. The timing of the decision in this case doesn't change the character of the motion that I filed.
I think Brangen maybe read the opposite way, that we should focus on substance, not form. And the substance of what this judge did was a 25B2, not a 25A1, right? Because the substance is, I'm going to wait for the jury to see what they do. So I'm not sure Brangen's so helpful.
Well, Your Honor, I understand that from Your Honor's questions that you're not necessarily buying my argument in this case. But I just...
I think the case, I feel bad for you because you figured it out, but it just seems like this is a bad process to create this nunc-pro-tunc.
Let's talk about nunc-pro-tunc, okay? Because the Commonwealth wants to say nunc-pro-tunc is only used essentially to correct clerical, ministerial oversights. That's not true. There is a third type of nunc-pro-tunc relief articulated by this court in the Perkins case 100 years ago and repeated in a bunch of other cases much more recently that I cited in my brief, where a purpose of nunc-pro-tunc is to avoid a miscarriage of justice based on a delay in the entry of a ruling or a decision or a judgment due to the fact that the matter was under advisement. That's exactly what happened. That's exactly how this equitable remedy was properly used by the judge in this case. It was under advisement, it shouldn't have been under advisement, and as a result of her ruling on it too late, my client lost very serious rights, namely the right to an unappealable, unreviewable acquittal, and that's what nunc-pro-tunc is for. It's an equitable remedy to fix that kind of a problem, which is exactly what she did. And if the court doesn't like nunc-pro-tunc as it's used in this case, frankly, there are two other grounds for relief for my client. The second one is, this was an error. It was a trial error. It was objected to by defense counsel. It was a preserved trial error. The defendant was seriously prejudiced by it, and the defendant is entitled to relief, meaningful relief from that error, namely the affirmance of the trial judge's ruling, which is in effect an acquittal which under double jeopardy jurisprudence cannot be reviewed. So
I ask you just-
either way, my client is entitled to relief.
But with the first way, the nunc-pro-tunc way, isn't that really off the table where 25A specifically says that you shall rule at that time?
That's what nunc-pro-tunc is for. She should have ruled at that time, and she didn't, and that's why she made the ruling nunc-pro-tunc. That's what it means. That's what the third prong of Perkins is talking about. That's why if you look at a case called Zucker, in Zucker, there was an issue about what you do with monies that have been collected for rent control. The legislature gets rid of rent control, and this court said, well, we're still going to disperse those monies because this case was under advisement at the time. We're not going to just say the case goes away because the judge hadn't ruled before the legislature acted to abolish rent control. Here, she did what she should have done to restore the parties to where they would have been. I mean, to me, that's what justice is.
Well, Mr. Sultan, there's one issue that's, I think, critically important that you and the Commonwealth disagree on. So just take Justice Budd's point as correct, that nunc-pro-tunc doesn't overrule 25A, and she can't do it nunc-pro-tunc. But still, you would argue, I think it's a strong argument, the fact that she did it nunc-pro-tunc tells you what she would have done with the 25A ruling if she had ruled.
Very clearly.
Very clearly. The Commonwealth says, well, we don't really know what she would have done at that time because she wasn't in that moment. And I guess that's sort of important.
Well, Your Honor, I think you have to take the judge for take her words as meaningful. What she said when she granted the motion on April 9th, she said, no jury, no rational jury could have found that the defendant was guilty of murder.
So she literally said that on the transcript? She literally said that on the transcript?
She literally said that. She said no
was
rational jury could have found that the killing was unlawful, and no rational jury could have found that the defendant was
She was hedging her bet. She wanted the jury to decide it, to find him not guilty, so she didn't have to make the tough call.
That's exactly right, Your Honor. She didn't want to have, because she was afraid, she said, because she even when I told her on April 9th, I said, look, read the Supreme Court double jeopardy jurisprudence. It's unreviewable. If you had ruled at that time it was unreviewable, she didn't believe me. She still didn't believe me because she was under the misimpression that, and she explained why. She said it's a ruling of law. She said if I rule as a matter of law, there's insufficient evidence. It's a legal ruling and it's reviewable.
She applied the guidance we encourage judges to apply in civil cases.
I think that's correct, Your Honor, and this is a very different matter because obviously the double jeopardy clause applies in criminal cases. So I think that that she employed exactly the right route to try to get the parties back to where they belong. And to answer Justice Lowy's question a little further, in terms of knowing what she would have done, which I think she makes abundantly clear. I discussed a case in the brief, Kiselev, which is out of the North Carolina Appeals Court. It's basically this case. It's this case, except that the defense counsel didn't object when the trial judge deferred. North Carolina, like Massachusetts, has a requirement that the trial judge rule at that time. The trial judge deferred, and what the Kiselev court did was to say, we're not going to let the prosecution appeal because based on the record, we find that, that it's probable that the judge would have granted the motion had he ruled when he should have ruled.
Were they working with the whole record?
I don't recall the answer to that question. I assume the answer to that would be yes, Your Honor, because I think there was some discussion of the actual evidence at trial. But here, and I understand it's a truncated record, but merely based on what Judge Sanders said on April 9th to explain her ruling, the idea that somehow that was an epiphany that came to her between March 15th and April 9th, I don't think makes any sense.
Attorney Sultan, can you just direct me to like the exact references that you would want us to pay attention to in the transcript?
In terms of what she says for her,
Yes, that's in your, and I assume this
Yes,
is
Your
in, is this in the supplemental appendix or the Commonwealth, which?
Well, I'm just going to find it in my brief, if I may. So in terms of her explanation of this is at Commonwealth Appendix 126. This is on April 9. She says there was only one verdict that was legally possible in my view, and that was a verdict of not guilty on the murder charge. That's CA 126. She explained that, quote, no rational jury, following the instructions I gave them, could have concluded that there was unlawful killing, close quote. She added that, quote, no rational jury could have concluded that Mr. Yasin aided and abetted the shooter based on the instructions I gave to the jury. So that's what she said when she granted the motion.
On the instruction, okay.
And then back on March 15th and 16th, when she discussed the motion, she also indicated what she believed the Commonwealth had approved with respect to essentially disproving the defense of self-defense. And if I could take one more quick point, as far as Justice Kafker's point, that this is going to kind of, we have to worry about rogue judges. I mean, frankly, this court addressed that in a case called Lauder. Lauder was a case where the judge granted a mistrial after the opening. And this I think is 2002 or so. And this court said, in affirming, that the court said, the judge erred in granting the mistrial after the opening, but but there's, and in a footnote, the judge said, this court said, even if the trial court didn't have jurisdiction, didn't have the power to grant the acquittal after the opening, it still stands because it's an acquittal. In our system of justice, an acquittal is an acquittal, and it's the end of the story. And as the Supreme Court said in Evans, we're not going to assume that judges are going to be rogue and make these decisions whenever.
No,
We have to assume that judges act in good faith, and if the legislature doesn't want to allow, and this court, with crafting the rules, doesn't want to allow judges to enter unreviewable acquittals, then this court can do what the feds have done and allow judges to defer those decisions. But in our system, under Rule 25A, the decision has to be made there. That's when I filed the motion. I objected when the judge deferred it, and Mr. Yasin is entitled to the acquittal that he should have received on that day, and to rule otherwise would be to give the Commonwealth a totally unwarranted windfall of the appeal they're not entitled to, particularly where they didn't object below. They waived the argument.
If I can ask a jurisprudential question in terms of which you're claiming that the judge erred and that you had objected and therefore you're entitled to a prejudicial error standard. They did not object at that time, so I gather you're arguing that they would be entitled to, at that, if we focus on that decision, the substantial risk of a miscarriage of justice standard for them.
Yes, Your Honor.
They're objecting to the judge's decision subsequently to grant it for which they objected.
They didn't object. When she said de novo, they didn't say anything. They didn't jump up and say, Your Honor, you can't grant it a nunc pro tunc. They didn't say anything then either.
That's right. Okay.
They didn't file a motion for
basically,
reconsideration.
it was only the appeal that the Commonwealth spoke.
First
on the
time they
system.
ever said boo was,
Okay,
was when they went to the
what's
single
the
justice.
consequence of their failure to object to the judge making a decision which arguably has the result of an unappealable acquittal? Substantial risk standard?
Yeah, I think in order, they would have to show substantial risk of miscarriage of justice because they waived the argument below, and this whole, the purpose, as this court said in Preston, and as the appeals court said in Cote, the purpose of this requirement of an immediate ruling is to benefit the defendant. It's not to benefit the Commonwealth. So how can it be a miscarriage of justice? They didn't, where they basically lost the chance to appeal something that they had no right to appeal. That's not a miscarriage of justice. They want a windfall. They say, hey, she screwed up, we kept silent, but she waited too long to enter this order, so we should get a chance to appeal on the merits. Well, for all the reasons I've discussed, they shouldn't get a chance to appeal on the merits. The case should be over.
All right, thank you.
Thank you.
We'll take our morning break.
All right.